Welcome again to IRC Food Series. So last week we were discussing about dismissal and also what to do after you've been dismissed by your company with our Miss Kamini from Kamini and Co. So today we have Miss Kamini again to discuss about what happened after you filed the complaint and what are the procedure and what to expect after that. Hello, Miss Kamini.
Hello, hi everyone.
Hi, how are you today?
I'm good. How are you?
I'm good, thank you. So thank you for being with us. Okay,
Pleasure.
yeah, so last week we were talking about dismissal and also where to complain. You actually explained to us in very detail on where to complain after you being dismissed by the company. So today, let's talk about what happened after you filed the complaint. Any thoughts about this?
Okay, after the employee actually lodged a complaint in the JPP, which in English we call it as IRD department, the IRD department will inform the employer thereafter and they will fix a meeting. We call it as a reconciliation meeting. In layman terms, it's more like a discussion that will be held between the employer, employee, and also the IRD department to see whether the matter can be potentially settled even before the matter is referred to the industrial court. So basically, that will be the procedure involved right after a complaint is lodged before it is being referred to the industrial court.
I see. So during this rundingan damai, right? Can they actually appoint anyone to represent them?
Yes, they can appoint someone that they with the permission of the IRD, but a lawyer is not permitted to represent them during the rundingan damai. So if they have a union member or someone related, like for a company, they still can represent them.
I see. Okay. So like during this rundingan damai, so you said that they have to discuss and also reach a agreement, right? So what happened after this process?
Okay, so just to come back to this issue again, during the rundingan damai, the IRD will see there is a potential of settlement. So during at this time, it's important that employee actually seek some legal advice to see how much compensation they should be asking to the employer. Some of them actually, they have no idea how much to seek for compensation. And when the employer says, I just want to pay you 1 or 2 months, they just take it as it is, as they have no idea how much they are actually entitled to. So even though a lawyer is not allowed to represent them, my suggestion is that it's best that they seek some advice from a lawyer to know at what range they can look at, and if they don't get the amount, what should be the counter proposal, and so not before they reach a settlement. So to make it worthwhile, because some of the employees should be entitled to quite a huge compensation, but since they have no awareness or lack of education on this, they often tend to settle for a very least amount, which is not worthwhile, and I don't think it will help them much. So in this aspect, yes, they should know something about this, and best they seek some advice. So if the conciliation succeed, then the matter will end there and there. So the employer will pay the amount compensation to the employee and the matter is settled. However, if the matter doesn't get settled, that's when the matter will be referred to the industrial court by the Director General of the Industrial Relations Department. That is, the IRD department will refer the matter to the industrial court.
I see. Okay, so during this is the time that they can hire a lawyer to represent them.
Right after the matter is referred to the industrial court, then yes, they can hire a lawyer. It's better to be represented, as a lot of people, they don't know what to do. Sometimes the court will actually advise them, you can do the documents and all this, but it is suggested to get a lawyer or legal representation, as once the document is done, which we call it as pleadings, it cannot be amended later just like that. They have to seek the court's permission, and it's a bit tedious, and you have to stick to that document. So if you are out of it, then you may not have a good case. So if you feel it's waste of money to spend few thousands there, but end up you may lose a lot. So it's best that you actually can get a person who is legally equipped to help you on that.
I see. Okay, so at the end of the day, this thing, it comes down to the dollar and cents. Okay, so how much cost are we looking at the employee side and also employer side? Let's start with the employee first.
Okay, for employee, let's look at probationer and also permanent employees. For probationer, the maximum amount of compensation they are entitled to is 12 months of their last drawn salary. So if a person before being dismissed was earning about 5,000, so the maximum amount of compensation that they can claim is 5,000 times with 12 months. Okay, that is for probationer. However, for permanent employee, they are entitled to maximum amount of 24 months of their last drawn salary, plus with 1 month salary for each year of service. So if the salary for the employee is about 5,000 when they were dismissed, so you can times with 24 months plus 1 year for each month for every year of service. So let's say the employee has actually served the company for 10 years, it's plus with another 10. So 24 months plus with 10. Total maximum compensation they are entitled is 34 months.
Oh my God. This is a really huge sum if the company lose the case, right? So I mean the employee will be entitled to this sum if the company if the employee win the case, right?
Right, exactly. But a lot of people think that they will get a small sum and it's not worth it. For permanent employee, I will really recommend to actually go for the matter in the industrial court if they do not get a favorable compensation, because end of the day it may be really worthwhile, because I have seen clients who have been taking hundreds of thousands or even millions as compensation being awarded by the industrial court.
Wow, that's a lot. Okay, so now if this one, if in the event employee win the case, so what about employer? So if the employer win the case, so is there any compensation, or how much is the employee looking at for as a compensation?
Okay, if the employer wins the case, of course the employee will not get a single cent. But one good thing about industrial court in comparison with other courts is that, especially like civil court, if you were to file a case in civil court, if you lose the case, you must pay costs to the other to your opponent. So that means you must pay cost to the winning party. But in industrial court, even if you lose the case, you don't have to pay any cost to the winning party. So that is one good thing about industrial court. But of course, end of the day, the losing part is that, you have to spend some money for the legal fees if you don't wish to appeal the matter.
I see. So for the employer one, are you saying that if the employer one, if they don't win the case, they won't get any compensation or whatsoever?
Yeah, they don't get any compensation. Employer will not get any compensation.
I see. So it's just that they will be able to maintain their good names lah.
Not exactly good names. It's just that they're able to defend the case successfully. That is all.
Right. Okay. So this one is if the we're talking about on the compensation side. What about legal fees? So for the employee, how much are they within? What are the range like? And also for the employer, what are the range like?
Okay, this is a very difficult question because each lawyer has their different package when it comes to legal fees, right? But I will suggest to always check out with some of the lawyers to see what is the price range that you can afford, because a lot of people have this misconception that when you hire a lawyer, it's like the fees is going to be exorbitant or high. But in
Yeah.
actual, there are some lawyers who are charging reasonable legal fees out there. So instead of like we presuming and thinking that it would be expensive, I will suggest to always survey and check out what is your budget and to see whether they can actually propose an amount that is within your budget. Some of the lawyers may even charge about 6,000 on installment basis, 7,000 on installment basis. And of course, there are high end like 15,000 for employees. There are charging in that range as well. So you just have to see what will fit you.
I
So yeah, it's
see.
important to check out now.
I see. So there's no fixed fees
Yeah.
in the market. Like it just really depends on your budget and all that, and also depends on the lawyers as well. I see.
Right.
Okay,
That's
okay.
correct.
So this one really enlightened on the, I mean, like on the fees part, because I mean, like I know quite a number of people out there, they're willing to just, just represent themselves in court, and with the thoughts that if I hire a lawyer, it's gonna be very expensive and things like that. So yeah,
Yeah.
so I hope this really enlighten this information really enlightens everyone lah. Okay. Thank you so much for being here, Miss Kamini. So yeah, so next episode we will talk about so how do we stand a chance to win in IR court. So we will have Miss Kamini again on our next episode. Thank you and see you guys.
Thank you. Bye.